Hi everyone, good afternoon. So today we'll be talking about wills and codicil 1, and the first thing on the table is for us to know what wills means, the meaning of wills. So, and which I think is very elementary because I don't think anybody will ask you for the meaning of will, and I don't think you need to write it anyway, and I think everybody knows the meaning of will. A will is a document, a testamentary document that you make voluntarily. So before I give the meaning of will, I think the best way to answer the question when you're faced with it, or the best way to identify if something is a will, is to check the features, and by the features you can draft the meaning out of the features. So if you say it's a testamentary document made voluntarily and lawfully executed according to the wills law by a person called the testator with a sound disposing mind on how his estates will be disposed upon his death. So that sums up the features of a will. What should a will contain? What should a will contain? It has to be testamentary. That means it comes to effect after the death of the person that executed it. More like after the death of the testator, and it has to be lawfully made. The testator has to be of a sound mind while making the will. He has to be lawfully executed. That's a will has to be signed by the testator in the presence of two witnesses. So by the two witnesses, it doesn't mean that if we sign it in the presence of one witness today and that witness tomorrow. The two witnesses have to be available at the same time and they have to witness his signing. We'll get to the part of execution later, and I'm just going to try to brush through these areas because I understand that you've already been taking on this part, but I mean just mentioning it because this is a recording. So once you know the meaning of will, we can move to the types of wills. So there's the statutory will. So for statutory will, it's basically the kind of will that you make in accordance with the extant law. More like, what does the Wills Act say? In this type of situation, what will the Wills Act seek of you? Or let's say Armed Forces Act, when you're a soldier and you're making a will, and that kind of will, we'll get there. So apart from the statutory will, we have mutual or reciprocal will. Just as the name implies, reciprocal. So when we say a will is mutual or reciprocal, it's like a symbiotic relationship. You gain, I gain. So this type of will is the will you create for the beneficiary or for the benefit of somebody that's creating a will for your own benefits. Most of the times it's used by a couple, more like, okay, I'm creating this will and you'll be the beneficiary. You are creating your will and I'll be the beneficiary. At the end of the day, anyone that dies first will inherit the other. And there's what we call formal will. Formal will is like the normal one that follows the wills law. More like all the attributes that the wills law puts in place for a valid will to be made. That's what the will follow. I think when I was talking about statutory will the other time, I mentioned Wills Act. So in formal will, we are using Wills Act, wills law of that state, whichever one. But in statutory wills, more like Armed Forces Act. Armed Forces Act. especially when you are a special person. More like if you're in the armed force, of course. If you're not in the armed force, you can't make armed forces acts. And there are different laws that provide for more like when you're just making a law and you have to follow relevant statutes that applies to you, that is peculiar to you, that's a statutory will. We also have the non-cooperative wills. That's more like a deathbed wish. It's the will that you give, like an oral directive of, okay, my land that is there, give it to my last born, and this and that. It necessarily doesn't have to be executed by the attestators, by the witnesses, because first it might not even be written, because it could just be oral, and the person that is making it is probably very sick or almost dead. So that's when you make a non-cooperative will. And we have what is called privileged will. Privileged will is more like a special form of will as well, that is special in the sense that it excludes some features of a will. For example, you know that if you're talking about capacity to make a will, you have to include age there. So for somebody that is 16 years that is making a will, for it to be valid, probably the person belongs to maybe a military service, and the person is going to the war zone, and he needs to put his things in perspective in case he dies. So he doesn't have to be of age before he can do that. So another one is what we call conditional will. Conditional will is just based on some preconditions. For example, when you make a will for a beneficiary, but the beneficiary has to do something, more like there's a condition before that will become valid for the beneficiary to gain from. So moving on, if we look at the so those are the types of wills, and the next one is rationale for making a will. It's just to put everything in perspective. It excludes limitation. It excludes a lot of application of customary rules of inheritance, because once you have your will, and is to the sharing of your property is to go by your will. So the testator may give additional directives as to his burial. Even though this one there's like another explanation to it, more like because your will has to take a couple of days before it is read, you can just if you have a wish on how you should be buried or anything, it should be written in another letter attached to your will, but we'll get there. So another advantage of making a will is it ensures positive display of wishes of the testator. A testator can appoint trusted persons to manage his estates. Then a valid will confers authority on the executors to act immediately following the death of the testator. It enables the testator to decide who should inherit his property. It gives the testator peace of mind, because without a will, it means that the person dies intestate, and dying intestate means that the family will have to approach the courts for letters of administration to give an administrator who will then administer his estate. So let's know the difference between an administrator and an executor. An executor is a person that is duly appointed in a will. Is duly appointed in a will and is duly appointed in a valid will by the testator. But an administrator is appointed by court. That means in the absence of an executor, an administrator is appointed. So there are some instances whereby there's a will, but I think that's a probate topic, but we'll get there. Where there's a will and the executors are not validly appointed, or the testator did not appoint an executor at all, then you approach the courts for administrators, for letters of administrators with wills and X, but we get there. So we move to who can make a will. Who can make a will? This is about the capacity of making a will. And when you're looking at capacity, what are you looking at? You're looking at the age and the mental capacity of the person, because you might be of age and not have the mental capacity to validly make a will. For example, somebody that is not mentally stable cannot make a will, especially when he's not in his lucid moment. So for age, for the first kind of capacity, which is age, so here we're talking about the age of the testator, which implies that any person that is making a will in Lagos State has to be 18 years, but under the Wills Act, the Wills Act caps the age of validity to make capacity to make a will to be 21 years. And of course, the exception of all this age is the kind of privileged will. So when you see a scenario that the person is not of age, or however the person is a lawyer, is a soldier, and is probably in the war zone, please do not make the mistake of saying that he cannot make a will, unless you are laying foundation for your answer, and you should understand how to answer your questions according to the courses. So, and examples of people that can make a privileged will: soldiers that are actually at military service, like I said, the war zone; seamen at sea, mariners at sea; crew of commercial airlines, that's air hostess and all, especially when the plane is crashing. So there always has to be a reason to make a privileged will. And the second kind of capacity, which is mental capacity, is when a testator has a sound disposing mind. So I think you should hold on to that use of word, sound disposing mind. So he has the mental capacity or sound disposing mind to make a will. And at the time he's giving the instruction, and at the time he's executing the instruction, the will itself, he has to be of sound disposing mind. So this means that when he's giving the instruction that give this social person this, give A my Toyota Camry, give B my house in Lekki, he has the mental capacity to do that. He is sound. He wasn't mad. So that's why you see somebody has a sound disposing mind. And as at the time he's executing the will, he also maintains that stance. So where the testamentary capacity of somebody, how you do the test is it's in this case Banks versus Goodfellow. So the first thing to check is that the testator understands the nature and effect of making a will, that he recollects all the properties he wishes to dispose. He recollects and appreciates the persons who are the intended beneficiaries. He remembers and clearly states the manner in which the estate is to be distributed between the beneficiaries. So there are some things that you can say that, looking at it on the face of it, prima facie, this will is a valid will. Like, there's proof that the testator made it in his testamentary capacity. First, it was duly executed. It was signed in the presence of the two witnesses. Second, there's a signature. Third, the testator had required mental capacity and acted as a free agent. 4, that there is a presence, the usual attestation clause that the two witnesses are there. So most of those things are available or on a will. You can rightly presume that the will was done with a sound disposing mind. To put all of this in better perspective, So how do you prove that somebody disposed with sound mind? The first thing, there are in like two ways. So the first one is presumption, the second one is by evidence. So the presumption is that it was done with sane mind. When he was doing it, it was sane. When he was giving the instruction, it was sane. When he was executing it, it was sane. And mind you, I would appreciate if you do not mix old age up with mental capacity. Being too old doesn't mean that the person does not know what he's doing. It doesn't mean that the person has senile dementia, because you might get a scenario that as 102 years old man as a testator, and then they began to contest his will, stating that he was too old to prepare a will. And in the scenario, nothing shows you that the man had senile dementia or any mental incapacity to depose to the will. Yes, so there's a presumption that once a will is good, it is good. It's as good as it was done. There are situations where the presumption will not work. That's on the face of this document, on the face of the will, is not regular. Then you can't presume that the testator had the mental capacity when he was giving instruction or executing the will. The second one is where the testator suffers from some kind of disability. For example, when the testator is blind or deaf and there's no jurat to that effect. Or where the person is an illiterate and there's no jurat to that effect. For example, the illiterate jurat or the blind jurat is not there, then it can't be said that he made it. It can't be said that the will was made with the sound disposing mind. So this sound disposing mind is not always as obvious as age. We are still talking about capacity. We are talking about capacity in two places. Age, more like there is a ground level, but the sound capacity mind, it can just be presumed. I mean, it's more like mens rea, where you need to decipher from a couple of things. So, for example, if you have a scenario whereby somebody is challenging the state of mind of the testator, how do you prove it? First, let me state that the onus is on the propounder of the will. The propounder of the will is the person that is saying that the will is validly done. Yes, so the first person to prove that it's validly done is that person that is proposing that the will was validly executed, it was validly prepared, and it's valid in law. So the onus is on the propounder of the will to establish that the will is duly executed. And you can do that by showing, the prima facie that it's duly executed, all those things that we said earlier. Or it might bring evidences in support of, more like, okay, after making the will, that's when they say affirmative evidence, it means things that affirms what you are saying, things that outside the document itself can corroborate your statement that the document is valid. For example, after making the will, this person went by with his daily routine. It didn't look abnormal. And after he has pleaded his case, or after he has shown that it was made with the right state of mind, then it shifts to the challenger, the person that is adducing, the person that is saying that the will wasn't validly done. So it's the challenger that will then bring evidence to show that, okay, maybe this will looks good on the face of it, it was duly executed. And when you talk about execution, I hope we understand that execution also includes attestation. So when you say it's duly executed, that's signing in the presence of the two witnesses. Those two witnesses are the ones that are attesting to it. The signing is by the testator. So those three things are still under execution, even though we split them just for clarity. We can't just call them execution, so we don't mix them up together. And so you can show that, okay, regardless of the fact that this was duly executed, the testator was actually insane. Then you bring out your own evidences. Okay, maybe after signing the will in front of two persons, like validly doing that. Or no, during the signing, the man kept saying a lot of gibberish. And you know that the features of will is that he has to be of the capacities that he has to have to be of sane mind while giving the instruction and while signing the will. So, for example, he gave the instruction with his clear state of mind, but while signing, he was saying a lot of gibberish. He didn't look normal. Then we can say that it wasn't of a right state of mind, and the challenger can, as long as I can prove that. Yes. So, in order to prevent things like this, it's of good ethics and good practice that a lawyer should take some things outside the wills, more like a written statement that confirms that he has the mental capacity to do it at that time, or even go as far as getting a medical report by a medical practitioner who examined the testator and confirms that it's okay to prepare the will or give the instruction and execute it. It's just to have it handy and just like an external proof which whoever the propounder is can eventually show it in court. And from the explanation I gave the other time, we understand that if this will be presented, it will be an affirmative evidence. More like it's not the will, it's not showing that the will was signed, but look at it. Before he signed the will, before he gave the instruction, we examined him and it was certain that it was of a sound mind. So moving from there is testamentary intention. How do you know the testamentary intention? So remember we said that the intention has to be there. That's the intention to dispose. That's the mind, the mental capacity has to be there while giving the instruction and while executing. However, at times it varies according to the peculiarity of the matter. If the instruction was given to a lawyer while the testator was sane, it will still be valid if he executes it with an insane mind. However, if there's a third party, more like the line of communication went through somebody, then it won't be said that it will still be valid. Let me explain. Where the testator tells somebody to tell his lawyer that he's donating so with his sound mind, he did that with his sound mind, and while signing that thing, the testator had already gone mad or is now of an insane mind, because that instruction was through another chain. It won't be said that the testator had the mind to still sign it. It won't be valid. So the essence of all of this is where there's a third party in the line of the communication is not valid if, as at the time of signing, the testator becomes insane. It won't be said that it's still valid, unlike when the instruction was given directly while saying to a solicitor. So that's the mens rea. And another thing is that the testator has to have a testamentary intention. Thus, he has to know that all of this thing that he's saying it will only become effect upon his death. And number two, that he knows what is in the will, he approves of it, and he knows that he's giving a car to somebody. More like he knows the specific things, or he knows in the implication of what he's doing. He knows that he's giving somebody something, not that he thinks that he's giving somebody something but he's giving somebody else. So all of those things are how to get the testamentary intention. So another part is when we talk about capacity, we look at the physical being of the testator. For example, a blind person. So when you are preparing a will for a blind person, he there are some conditions to fulfill to show that that will was made validly. So he has to be shown that the will was read over to him. Because if you've learned your jurat draft, or if you've seen it at all, you understand that in the draft it will be said there that, okay, I read it to him, he showed me that he understood, and I led his hand to sign, I led his thumb to print on it, he told somebody to sign, all of those things. So it must be shown that the will was read over to him and that he perfectly understand the contents. More like maybe you asked him, then he repeated it, and this is where the blind person's jurat comes in. There is a separate clause that is in the will that shows this. Most of the times is after the execution part, that's execution and attestation, but you get there when it's time. So as much as a blind person can make a will, a blind person cannot be attesting to a will, because you have to see the testator when he's signing. So we move to the conditions of a valid will. So what are the things that you see in a will and you see that it's valid? The first thing is that the will has to be in writing. The second is that it has to be signed by the testator. The third thing is that the testator must have testamentary capacity. And the next thing is that the will has to be duly executed. So by duly executed, don't forget that we mentioned that it means that the testator signed in the presence of two witnesses. So you can call it joint presence of two witnesses. So, which means the two witnesses were present at the same time when the will was signed. So you might get a scenario that says that the testator did not sign in the presence of the two witnesses, but something happened, more like maybe he confirms him in the presence of the both of them. That's still duly executed, which takes us to the three ways where you can say that the testator duly executed the will. The first way is that he can sign personally in joint presence of at least two witnesses. So the word is at least, not at most. The second one is that the testator signs the will privately and acknowledges his signature in joint presence of at least two witnesses. So he had signed it probably because those people were not around or something, or maybe was traveling. Then he later acknowledges that, okay, this is the will, I signed it in the presence of the two witnesses, at least two witnesses. 3, somebody signs for testator in his presence and by his direction, and he acknowledges same in joint presence of at least two witnesses. This now has split to like 3. The entire gist of this C is that the testator told, for example, testator told Tade to sign the will in his presence, and after Tade signs the will in his presence, the testator acknowledges the signing of the will in front of the two witnesses. So this implies that when Tade is signing the will, the testator was there. And also you can as well sign a will by thumbprinting, especially for people that are not literate. So another thing is that these two witnesses, that's for attestation. Before you can say a document is duly executed, execution may mean for you just signing of the testator, but in wills, it means that attestation was also done, because you know that the signing has to be attested to. So how does this attestation happen? First, the witness's signature must be after the testator's signature. So after the testator has signed, that's when the witnesses who are attesting to the testator's signature as valid will now sign. Then the two witnesses will have to sign in the presence of the testator. However, the both of them doesn't have to sign on the same day. They just have to sign. Anytime they're just signing, the testator has to be there. That's attestation for you. So there are some principles around attestation as well. More like who can be a witness to the beneficiary, to the will. So anybody can be a witness to the will except a blind person. I think we already spoke about that. However, beneficiaries are warned not to witness the will because you are not meant to know what is there yet. So the general rule is that where beneficiary or the spouse of a beneficiary attests to a will, that beneficiary will lose the gift. That means Mr. A married Mr. B. No, let's just say it like this. That means Mr. A gifts Mr. B land from his estate. Mr. B, being a beneficiary of that will, cannot attest to that will, or else he will lose the gift. Or Mr. B now has a wife, which is Mr. D or C. So Mr. C cannot also attest to the will if the will if Mr. A gifts Mr. B in that will. I think it's self-explanatory though. However, there are exceptions. Where there are more than two witnesses to the will, that means the other two will suffice. The other witnesses will suffice. More like where a beneficiary attests to a will, or the spouse of a beneficiary attests to a will, on a normal day is meant to be the beneficiary is meant to lose his gifts. But where there are other witnesses, the rule is at least two witnesses. So for example, say we have 3 or 4 witnesses and it's only Mr. B that is a beneficiary in the will. The remaining 3 are still valid witnesses. So we can't deprive Mr. A. We can't deprive Mr. A of his gifts. Then the next one is that where the testator makes a subsequent will to confirm his gifting. So because Tade was a witness to the normal will, then Tola, the testator, now makes another will to confirm that yes, he gave Tade the house in that will, even though he's a witness, even if there were no two other witnesses. The subsequent will though must not be signed by Tade, the beneficiary, and it must not be signed by his or her spouse. Then the third one is if the gift was made in the settlement of an obligation. So you cannot, because that obligation is crucial, more like it's compulsory. So you can't say that, okay, there's an obligation to give Mr. A one of your property. You know that because you already gave Mr. A that property in your will and Mr. A signs the property, you can't then tell him that he loses the gift, because you gifting him was not just you gifting him in your will, it's an obligation or a settlement of an obligation. So that one as well is an exception. The next exception is where the witness, that means the person that attested to the will, is not the main beneficiary but a trustee of the gift. Yes, you name this person in your will, but it's not the one that will benefit the gifting at the eventual stage. More like you say, I give Tade my Toyota Camry to give to his child once he's 28, or I give to Chade's first child once he's 28 my Toyota Camry. So, or I give Tade, I think the first explanation says it. I give Tade my Toyota Camry to give to his child once he's 28. So Tade will be holding the car as a trustee till his child will be 28. So he's not the beneficiary of that particular gift. And if he signs the will, if he attests to the will, he can't lose the gift. Then the next one, the next one is by marriage. So so let me just read it. The marriage between the attesting witness and the spouse happened after he attested the will. So you can't say that because let me give you an example. Temi Otedola is a beneficiary in Femi Otedola's will. Mr. Easy is one of the attestators, is one of the witnesses. He signed Mr. Easy's he signed Femi Otedola's will. He saw Femi Otedola when he was signing his will. So he signed the will together with one other person. That means two witnesses. However, Mr. Easy had not married Temi Otedola as at the time he was signing the will. So we cannot say that Temi Otedola will lose her gift because Mr. Easy is a spouse and Mr. Easy is a witness. So the duration also matters. Now let's talk about the element that vitiates a will. First is mistake, undue influence, delusion, and suspicious circumstances. By delusion, I mean the testator was not in his lucid moment. He was probably hallucinating. The entire thing is that it wasn't of a sound disposing mind. Then for undue influence, that's coercion or just coercion, or you influence the mind of the testator. That's certainly undue influence. Then I mentioned mistake. So some mistakes can be overlooked, but some cannot be overlooked. Some are very material to the content of the will. For example, where you see that something, probably a gift, was meant to be given to somebody and was given to somebody else. I mean, yes, we can't predict the mind of the testator, but you can infer that there was a mistake of fact, maybe a mixture of people, maybe mixture of people. So those things vitiate the will. Then suspicious circumstances. This occurs when you know that this thing shouldn't be like this, and in most cases it is probably when the will shows that the testator gifted the lawyer in his will, and I mean the will is in possession of the lawyer. You can't be so certain if your father is not that kind of person. You can't be sure that he actually gave the lawyer the gifts in the will. So you need to check that as well. And so on successfully proving that it will vitiate the will, then the next thing is codicil. What is a codicil? A codicil is basically like a separate document. It's like a supplementary will. And what do we use it for? We use it to either affirm the content of a will, if you remember the other time that I mentioned that where a beneficiary attests to a will, another way to validate the beneficiary's gift is to prepare another will to confirm the gifting of the attestator. So in this instance is the codicil. So it either affirms, amend or alter. Then it can correct clerical errors too. For example, the names we mentioned like mistakes. Then you can also use the codicil to revoke a will. You can use it to revive a will. Then you can use it to republish a will. And I think it goes without saying to say that the codicil must reflect the details of the will it is altering or confirming. For example, if the codicil is made furtherance to Mr. Jale Koko's will of 2029, executed by Mr. Jale Koko and attested to by ... it has to be express, the date especially. Then there's another subtopic that is alteration of will. Once a will is altered, how? So if you want to make an altered will valid, all you need to do is that the testator will sign that will that has not been altered. He will execute it again as though it's executing it for the first time. As though he executed it the other time. So what I'm trying to say is the testator will sign it in the presence of the two attestators or the other two ways of attesting to a will. So this means that a will that has not been executed, if the testator has not signed the will, you cannot call it a will. You can't say that the will was altered or anything because it had not been signed. It has to be signed for it to be a will. If you remember how to know a valid will is execution. So if it's not signed, then it's not a will. So you are not altering any will. Because you can just see a scenario that says that, okay, this man says he wants to write a will. He has been giving his lawyer these instructions. Then he changes so and they're asking you for step, and in your mind you say that, okay, now that's alteration. It can't be alteration because they have not told you that the man has come to sign the will in his lawyer's office and that the testators have attested to the will. So let's be careful. Okay, so this is wills and codicil 2. Under it first is what are the types of gifts that we have. Of course, so we know that gift is what the testator is giving the beneficiary. So we have device and legacy. So for devices are realty or landed properties. So if the word used is devised, I devised this to this, just know that it's a landed property. Or where the word is not used like that and the property that was gifted is a landed property, then the beneficiary will be referred to as devicee. The second word is a legacy or bequest. So these are personal properties which are movable. For example, money, cars, choices in action. Then any beneficiary of a legacy is called a legatee or legatee for ease of spelling. So, however, you can now refer to movable and immovable goods gifts as legacy. But we already know device is landed property. I devised this land too. So what are the classes of gifts under we have the specific gift, general gift, demonstrative, substitutive, annuity, pecuniary, residuary, and joint gifts. Specific gifts are gifts that are specific, more like you can unpick it out of every other thing. So this is a gift of an identifiable property that is specific and distinguishable from the other properties owned by the testator. It must be properly and sufficiently described. The gifts may be indicated by the use of my, and I honestly think that it could also be indicated by the use of D. So, for example, if in the will the testator says a gift of my Toyota Camry car with registration number blah 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 to my daughter baby, it's fully described. The gift is described, the beneficiary is described. Or where we say I give my, in fact it can even be more described. If the registration number already separated from every other Toyota Camry car that the testator has. Or we can also say a gift of my blue Toyota Camry car, and another example is a gift of the diamond ring bought from Agos Jewelries UK to my niece in KG. So, but just be wary of D, because so when you use D and is not sufficiently described, then it won't amount to specific. In fact, if A is used and if my is used and is not specifically described, it will still be the same thing. For example, you say a gift of my car, and you have 3 cars, so it's still not specific. So it doesn't mean that anywhere you see my or the, but I think the law school standard is my, but you have to read it very well to know. And it doesn't matter that anywhere you see my is specific, it has to be described. Then another thing is general legacy. General legacy it has no specific description. It does not refer particularly to a particular piece of the testator's estate. So the testator intends that the gift should be certified from the general assets of his estate. So there's nothing distinctive about these gifts, and the use of my is not a decisive factor. It could be general if testator has many walking sticks. For example, if you say a gift of a walking stick to my son Joel, if the testator does not own a walking stick at his death, then the personal representative will provide for it from the testator general estate. So now that we've described the meaning of specific and general gifts, the main feature of these two, more like the effects when it's not available, is this. So for specific gifts tend to addim. So it is susceptible to ademption. By ademption, what do we mean? So in my time, people were like, if it doesn't D, if you know D, you know D, like Islam. And what does that mean? It is very specific in the fact that, which is a disadvantage anyway. So it's very specific in the fact that once it's no longer part of the estate of the testator, it becomes addim. So it suffers ademption. And what does this mean? You cannot replace it because it is specific. Where the testator provides that, where the testator views my blue Toyota Camry car with registration number 48922 Nkechi, However, when the testator dies and the will was read, there was no longer the blue Toyota Camry car with registration number dash dash dash. So because it's subject to redemption, it suffers redemption. It means that since that car is not available, then it's not available. So if you want to know the difference, like if you want to understand the meaning of redemption, before that, the second one is abatement. For abatement, general legacies abate. So it means that where the entire estate of the testator is insufficient, then it abates. What does that mean? It means that now for specific for general gifts, you cannot it doesn't suffer redemption. That means where the particular one does not exist, for example, not even a particular one, where, for example, the testator says a gift of a house to my son Johnny. However, when the testator died, the house that the testator had that time, even though it wasn't specific, the house that the testator had as at the time it was alive had been sold before he died. So because the gifting is a gift of a house, sure you get a gift of a house, that means you can build another house for the beneficiary, you can buy another house for the beneficiary. So it doesn't suffer redemption. The only thing it suffers is abatement. And what is abatement? Abatement simply means that even though you can replace even though you can subsequently get the gifts for the beneficiary from the estate of the testator, there are days that the estates from the estate of the testator, there are days that the estate will no longer be sufficient for you to get it. For example, where the testator says a gift of a house to my son Dami, my house at Banana Island to my house at Banana Island number blah 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 to my son Chukudi, all the money in my bank account to my daughter Ngozi. It means that at the end of the day, when they give Chukwudi's house in Banana Island and they give Ngozi all the money in his bank account, so that one is always like you have to call the account number because it has to be sufficiently described. So once all the money in the account of Ngozi in the account of the testator has been transferred to Ngozi, there's no money to purchase the house for Damilola. So that is what is abatement. So back to that specific gift, I'm trying to explain it or separate them so you don't mix them up. If you want to know what how to explain abatement or redemption, just know that redemption has D, and that slang, if it didn't D, it didn't D, is redemption. So it means that it's specific, and once it's no longer extant after when the will is read or after the death of the testator, then it didn't D. There's no way you're getting on that one. And once you get that one right, you know the other one. So the third class of gift then is demonstrative legacy. So for demonstrative legacy, it's maybe in form of general legacy, but it's directed to be satisfied from a specific fund or particular pool of property. E.g., the testator will demonstrate to the executors the source from which the gift is to come from. So if you are listening very well, you know that some of these gifts can fall into different classes, but there's no way a gift can fall into general class and specific class at the same time. but it can be specific and demonstrative and pecuniary. So an example of pecuniary legacy, since we said is drawn from a pool, of demonstrative legacy, since we said is drawn from a pool, is I give 50,000 naira to be drawn from my savings account number dash 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 at First Bank Limited. What just happened here? The testator gifted Bingpe. He described the gift as 50,000 naira from savings account. It gives the account number and the bank name. Then that is what we call a demonstrative legacy. Then demonstrative gift is not subject to redemption and will only abate where the particular fund is no longer sufficient. I think that's straightforward. It can add him because it's not specific, it's demonstrative. So you see how you can just oppose these things, because unless 50,000 naira is no longer in that particular account, then we can say that it has abated because the estate of the testator is not sufficient. It's not that it no longer exists. So another one is so when you keep reading further, you see that demonstrative legacy might not be from just money, because you said a pool, more like there's a lot of them, but they're now bringing out from it. E.g., a gift of my books kept in the shelf in my bedroom, but it's sufficiently described. So most of the times they are seen as general legacy. So we already said it will abate. So the next one is pecuniary legacy. This is just money. It's strictly money. What is pecuniary? Money. Pecuniary damages, pecuniary legacy. Money. So it could be demonstrative, it could be specific, it could be general. So remember how we said, now pecuniary is another class of gift. Now they're saying that it could be specific, they're saying it could be demonstrative, it could be general. So it depends on how the scenario is couched. Then annuity. Annuity is when it is expressed to be paid at intervals. It's still pecuniary. Okay, let me not use the word pecuniary. It's still money, but the expectation is that it's not a one-time thing. It's to be paid at intervals. E.g., give 1,000 naira to my first child every year. So that's an annuity. Then residuary legacy is the remainder of the property belonging to the testator after payment of all other gifts, debts, expenses, taxes, liability of the testator have been fully cleared or paid. So it could be real property, it could be personal property. This means that when you've done every specific or general or pecuniary or annuity or demonstrative gifting that the testator expressly wrote in his will, there's what we call residuary legacy. And what does this mean? As at the time the testator was writing the will, he probably didn't have this property, or he had not decided how to share them. So the normal thing is that the testator will give the remainder of his estate to a beneficiary. However, where the testator does not do this, then we will say that the testator dies partially intestate. Partially intestate. And at times, it's not that the testator did not gift anybody. It could be that the gifting failed. And what do we say by gifting failed? Probably the beneficiary dies before the testator or something. So where a testator dies partially intestate, you have to approach the court for that part of the estate that is not shared. Then the court will have to share. Then you have to do letters of administration on that one. However, before it falls, okay, I think we'll just talk about that later, because most of the times, apart from the fact that the testator acquires a property after making his will, or maybe he didn't even make subsequent codicil. So most of the times what happens is that maybe the gift fails, that is, the beneficiary died. However, where the beneficiary as a child, then it will devolve onto the beneficiary. So there's what we call another class of gifting is absolute legacy, no conditions attached, is as it is said. Then conditional legacy is the one that has a condition precedent or condition subsequent. For example, once my child Tade gets married, I gift her a Bugatti from my. So it could be general, it could be specific, but it's conditional. So without the fulfillment of the condition, the gifting will not be done. Or after the gifting, the condition must be fulfilled. That's condition subsequent. So now we are moving on to failure of gift. When can you say that a particular gift has failed? The first point is where there's a witness who is a beneficiary. I'm sure we already explained it, and this witness does not fall in the category of the exceptions, and we already explained the exceptions, where number one, where the testator wrote another will or codicil to confirm his gifting of the beneficiary, where the spouse, where there are other attestators, where the testator, where the witness married the beneficiary, more like where the testator and beneficiary became spouse after the will had been executed. So, and all those things. But where that beneficiary does not fall under any of these exceptions, then the gift will be said to fail. The second one is specific gifts is caught by ademption. We already spoke about that once it adempts, if it didn't day, it didn't day. So the gift fails in that instance. Then there's lapse of gift. So that is explained by where the beneficiary predeceased the testator. The beneficiary dies before the testator. However, where the beneficiary and testator dies together, for example, father and daughter, the gifts will not fail, because it is presumed in law that where two persons died at the same time, for example, in a car accident or plane accident, the eldest person will be deemed to die first. So that implies that ordinarily, when the testator and beneficiary dies together, the gift to the beneficiary will fail. But where the testator is older than the beneficiary, then the gift will not fail. It will still be in existence. Then the next one is on public policy, when the beneficiary killed the testator. So you can't even get it. Then where the gift is made to promote an illegal purpose, a gift so it doesn't necessarily have to look illegal. I mean, the gift might, the substance or the object itself might not be legal, but the purpose. For example, I gift my child the IS bus color white with registration number to use in carry out his operation to rob the bank. So the bus is not an illegal thing, but it's for illegal purpose. Or where you say you give somebody gun, all those things. Then another thing is disclaimer. That's where the beneficiary refuses the gift. Then the next one is uncertainty of objects. More like we don't know. We already said that a will has to be properly described. So where what you are giving is not even certain, there's no way we can gift it. That gift will be said to have failed. Another point is where the testator's where the gift has abated. That means although it's a general gift, but they cannot even get another one. So where the testator gift has abated and there's nothing in the estate to use to get the gift. Then the other one is where that gifting is a conditional gift. However, the condition was not fulfilled or satisfied, then the gift will fail. Another thing is gift to testator's spouse. So where you give to your testator spouse and you now eventually divorce, that person is no longer the testator's spouse, so the gift has failed. There's no longer that person described as the testator spouse, because you say Mrs. Bolaji Ajayi, and at the time the testator dies, Mrs. Bolaji was no longer Mrs. Bolaji Ajayi. They had divorced. She's now Mrs. Bolaji Kajuku or something. Even if that's it. So the next point is there are some gifts that you cannot gift out. For example, under cultural customary restrictions, where the custom that the testator was practicing during the day, or where he's living, or the way of life of that place says that you cannot gift out the first house of the testator, and the testator now gives it out in his will, it will be deemed to have failed. And where the testator gives out something that he doesn't have at all, Nemo, that's called non-abet. So all those things, the gifts will have failed. Then another way that the gifts will fail is where there is a vitiating element. Maybe the gift was made by undue influence, or the gift was given under duress, or the testator was defrauded, more like where he was made to believe something and that was not what happened. So more like where somebody intentionally defrauds him for him to now add the person to his will. For example, if you keep lying that somebody is a testator's child and the testator is not the testator's child, and those things, that's paternity fraud, by the way. Then for ademption as well. So once it's not available, Okay, I think we already spoke about that. We move to revocation of wills. On revocation of wills, so we already know that the wills is subject to change during the life of the testator, because it only crystallizes at the death of the testator. So it can be revoked either voluntarily or involuntarily. How? So first, for the voluntary revocation, it can be revoked by burning or tearing with intention to revoke. There are times that you by mistake tear or burn the will, but does the testator have the intention to revoke that will? That's very important to check. The second is by a letter of subsequent will or codicil. We already know what codicil does: amend, alter, revoke, add to the will. Yes, so by letter or subsequent will or codicil, more like in writing, is there. Then the third voluntary revocation is by writing declaration of intention to revoke the will, by written rather. Yes, so then for involuntary is always by operation of law. And how is this? By operation of law simply is that there's you will something to your wife, then there was a subsequent marriage, or you got divorced. Just that person is no longer your wife. There's no longer a subject. So that's by operation of law, and that's under involuntary. So for the so I just want you to note, in that part of a written declaration, we have to note that that when you are drafting a will, there's this part that you put last and only will of blah blah blah, or last testament of Mr. Ajanle Badmus. However, that doesn't mean that you've used that word to revoke the other wills that you've done. So I mean, because you can sit and think that okay, maybe the person has revoked, but most of the times that's not what it is. It's just a necessary part of the drafting. Then another form of revocation that is like under voluntary or involuntary, could be either one, but is most of the times is implied, is when a subsequent will is done. We already said it's under voluntary. So when a subsequent will is made. So, but then again, at times a subsequent will does not necessarily revoke the old will, because a subsequent will might not even contain the same property as the old will. So all those things are dicey, but we already know how a will is being revoked, and we already know that there has to be an intention, and there's the part of the testator cannot tell somebody to revoke his will on his behalf in his absence or in his death. So the part of destroying the will, when the testator sends somebody, or when the testator tells another person to destroy his will for him, which means that he wants to revoke it by destruction. So he has to, and we know we already stated it, that part has to be it has to come with intention. So how do we deduce that it was with intention? For the mode of destruction to be valid, there are some conditions that must be fulfilled. The testator must put the instruction to destroy the will in writing. It must be present when it is being destroyed, and it must be at his request or direction. So I'm sure this is like very, very straightforward. Where the testator tells somebody to revoke, to burn his will, and is not there when the person is burning it, so it vitiates that kind of revocation of will. So you cannot burn. So unlike execution, you cannot burn after getting the confirmation, after getting the instruction of the testator. You cannot burn the will in his absence. Then the testator will now come to confirm that yes, I told him to burn it. I had the intention to revoke it. No, it cannot be ratified. It has to be done in front of the testator. Other ways that you can do it, and we'll say that it has been sufficiently destroyed, it has to be completely torn. The signature part, that's the execution part. So execution part of the testator or witness, because if you remember that we have to have two witnesses. So where one witness, where they like scribbled or cancelled one witness signature, we know that we no longer have a valid will. So it's no longer there, testator signature no longer there, or it's burnt completely, or it's cut, it was cut or mutilated. So all those things. However, when you merely squeeze a will, or you draw a line across the will, more like you cancelled the will in your mind, you've cancelled it, or you toss some part of the will, you can't say that the will has been revoked. The will has still not been revoked because it has not been destroyed completely. It will only revoke the part that has been torn off, but you can't revoke the entire will. Then we already talked about the intention to destroy the will. So where you cannot say that the testator had the intention is if the testator was drunk, if he was insane, if he had accidents, or if the obliteration of signature without clear evidence of who and why it was done. So when you scribble out the signature part and we don't know when it was done, we don't know who did it, we don't even know if the testator had the intention to do that, we don't know if it was somebody that did it after his death. And so at times wills are destroyed conditionally, and by this and there are some wills that you might have done all those things, but because it was done based on a condition, if that condition is not fulfilled, it won't be said that will has been destroyed. For example, you destroyed it because you want to make a fresh will and you did not make the fresh will, that will still stands. Or you destroy it because you thought, more like mistake of fact, which was actually like wrong. For example, where the testator thinks that the old will or the earlier will has been lost, or that one of the legatees dies or something. So all those things, we cannot say that the will has been revoked because it's conditional. So let's remember the intention. So the court will hold that revocation is incomplete until new disposition is in place. That means it exists until there's another will. So back to involuntary revocation of a will. We already said subsequent marriage. For example, the testator married another person, so that will can be revoked based on that marriage. And how is this done? When you are making a will, first let's know that he has to be expressly defined. The object, the subject, everything has to be defined. So is only so an example is when the testator married somebody under customary law, but he now later marries Clara under the act, that's Marriage Act. So because wills, like the Wills Act provides says that you have to provide for your spouse, so that initial will no longer subsist because he has to provide for, he has to gift this new wife that is under the Wills Act, because you know that this is what is seen as a valid marriage. So he has to involuntarily, the initial will gets revoked. So he doesn't even have to do anything. He just has to prepare another will that will cover either the both of them or the marriage, the subsequent marriage, which is under the act. But you cannot marry somebody under the act and then marry somebody customarily and you think your will has been involuntarily revoked. No. However, the exception to this rule is that the person that you married customarily, he did the will in the person's benefit. He now marries the person by the act. It doesn't revoke it because it's still the same person, that it's still the same intention that is there, it's still the same subject and object. So there's no need. Then where the testator was married under customary law and later got married under the act with the same person. Yeah, so I think we already said that it won't revoke the will. Another thing is, there are some marriages like void marriage. You know that there are some persons that you cannot marry. Any person that your wife has affinity with, like your wife's sister, when you marry your wife's sister, more like you legally married your wife, you now married your wife's sister subsequently. That's a void marriage because it's your wife's sister is prohibited for you. So ab initio, there's no marriage that can revoke that will. Then where you married under the customs, then you married another person under the custom, none of the subsequent marriage cannot also revoke the earlier marriage. So let's talk about when a will is destroyed without a subsequent will. More like the will has been with the testator from the beginning, but when it's now time to read the will, that's after the testator's death, we now find out that the will has been revoked by mutilation. What does this mean? It means that will has been revoked, but you can rebut it. More like you can say that no, the will has not been revoked. For example, if the testator had some form of insanity before he died, so you can say that, we already said it, that intention matters, and for insanity you cannot say that you have the intention to revoke your will. Yeah, so another part is when you are suspecting that there are some other persons that are interested in the will, more like that it doesn't favor them and they're the ones that destroyed it. Or if you can prove or adduce evidence that shows that will was still existing perfectly before the testator, after the testator dies, so we'll know that it wasn't the testator that revoked it, it was probably by somebody, then that person can say that, if you can show it that, okay, maybe the testator had already communicated with his lawyer that he wanted to create another will, but then that was why he destroyed this one. So because that will had not been created as at the death of the testator, but he had destroyed the initial one, it will now take us back to the point of, if the will is destroyed on the condition of making another will, and you not make another will, the will still stand. So that's like how you can rebut it. However, where a will is missing, how do you prove it? So it's by evidence of those conversant with content of the lost will. So you can come and adduce evidence that, this will actually existed, he wanted to give this to this, the will is just missing. But people that have seen the content of the will, the testators can give evidence of the content. So it still subsists, but giving evidence should solve it. So the last thing we'll be talking about is the republication of a will. So where you've revoked your will, how do you revive it? So you can revive it by republication. And how do you republish a will? You just give it a new date. That means that new date is the date will now be the effective date of the will. That means the replication of a will is the confirmation or reaffirmation of the validity and content of a will. So maybe when you were destroying that other or when you revoked that other will, for example, where you voluntarily wrote that, this is my last the previous will I made is hereby rendered invalid, nobody should rely on it and all. So how do you republish it? You subsequently re-execute that way, more like you sign it again, you give it another date, or you create a codicil. We already said what a codicil is for: reaffirm, alter, change, deduct, or revoke, in fact. So where the testator intends to show that his previous will is unaltered, or revalidate some alterations, more like if you've crossed out some person's name and you don't want to edit that will again, you don't want to do the will again, you want the will to stand, so you just have to sign it again and put the new date. So that means you've successfully revalidate that will. It's no longer revoked. You already confirming the will, and if it was revoked before, it is now a good will, and which means that the new date that you signed it will now be the correct date. So how do you revive a will? By re-execution or by a codicil. So you're just bringing into existence the will that you've revoked. So that's all. We already talked about codicil, and we already know the function. It may affirm the content of a will, it may alter or amend the provisions of a will. Or like I say, in clause 3.6 of my will dated blah blah blah, where I wrote Ngozi, the correct beneficiary is Study. So all those things to reflect. So your codicil, your will be read alongside your codicil. Then it may correct a clerical error in a will, it may revoke a will, it may revive it, it may republish it. So what are the similarities? They are both testamentary, that's a seal. Later, they are both ambulatory, they are both revocable, and they are both dispository. Differences is that a will comes first. You can't have a codicil without a will, and a will is independent, but a codicil is dependent on a will. So, and there are some where an unclear codicil will be rendered invalid by the courts. So yeah, and another thing is, when do you advise your client to execute a fresh will? when there is a new or subsequent marriage, when there is excess alteration or mutilation of the original will, when there is change in finances and assets, when there is a change in residence. So because you have the option of using a codicil to amend your will, doesn't mean that you should just always use the codicil. So that's why this subtopic is there, that when do you now advise your client to make a fresh will instead of using a codicil. And those are the instances that I listed for you. And that's the end of wills and codicils 2. Thank you.